Good afternoon, everyone, and welcome to this session presented by the DRBF UK. We're looking this afternoon at the interaction between dispute boards and adjudication. My name is Adrian Bowen. I'm a partner at the law firm CMS. I'm joined today by Justin Mort QC and Krista Lee QC, both from Keating Chambers. Justin and Krista are probably known to many of you. They're very experienced advocates and experts in resolving disputes both in the UK and overseas. As I said to just now, I'll spare his blushes by not going any further with the introductions. But what we're going to do today is look, as I said, a bit further at the interaction between adjudication and dispute boards. People will know that dispute boards are typically associated with international construction projects, and adjudication is typically associated with UK projects. And there is an assumption, or at least an assumption by some, that the two can't coexist. We're going to test that hypothesis today and see if there's really any scope for saying that you can have a dispute board on a UK project, either alongside adjudication if the Housing Grants Construction and Regeneration Act applies, or voluntarily if it doesn't, or whether you can have adjudication on international projects. Is there any place for it there? So as I said, we're going to challenge that proposition today. We're going to adopt a discussion format rather than individual presentations, and cover a number of different related issues in the next 40 minutes or so. There's two boxes on the Zoom platform this afternoon. One is a comments box and the other one is a Q&A box. Sorry, the chat window is for comments and the Q&A is for questions, as the name suggests. Anne tells us before we join this that if you want to make any comments introducing yourself, saying where you're from, trying to make new friends, or whatever you do on these type of platforms, then please use the chat window. If you've got any questions that you want Krista and Justin to go through, then please use the Q&A window. And the reason really for keeping them separate is that Justin and Krista can concentrate on the questions rather than getting distracted by the socializing that no doubt will go on, but I assume that they'll catch up on that afterwards. We have allowed about 20 minutes for Q&A at the end, so please do get your questions and comments in. Otherwise, the session will be finishing earlier than planned. But we've got an hour, so let's kick off. Justin and Krista, welcome. Thank you for your time this afternoon. As I said in the introduction, we know in the UK we have statutory adjudication under the Housing Grants Construction Regeneration Act. One thing that has been historically mentioned is that we shouldn't really interfere with that in terms of adding dispute boards into those type of contracts that are governed by the Housing Grants Construction Regeneration Act and therefore that have statutory adjudication as part of their dispute resolution forum. Do you think that's right, or do you think you can have adjudication and dispute boards sitting in parallel on those type of projects?
I think it is a feature of the Construction Act, to use a shorthand, that it's quite prescriptive as to what you're allowed, and it has been the case law that if you try and do something that doesn't conform to the Act, that the tendency has been for the court to find, well, it's unworkable to have two systems going on. And I think that does raise the question of whether the Construction Act, although Section 108 requiring adjudication performs a miraculous service and is very popular and well used and extremely successful, it does raise the question of whether it's too rigid a system, and whether some flexibility, for example, to allow parallel systems to continue together. I think that there are definitely disadvantages in the way that statutory adjudication works, and some of the rules that are required. For example, the way in which adjudicators tend to be nominated, the way in which they become quite sort of formal processes, and the way that they tend towards a relatively formal dispute resolution procedure, perhaps increasingly similar to other sets of proceedings that they're intended to replace. So a question I'm interested in is whether one feels that DAB, an established contractual DAB, is likely to be a more informal process. I don't know what everyone else's experience is on that.
Just as to whether they can sit together, adjudication and dispute boards. Actually, about 10 years ago, I was asked to sit on the dispute board for the Mersey Gateway project. And the interesting thing about that case was that it was a consortium. So Kia, Samsung, and a Spanish company. And so I think even when you have these big projects in the UK, perhaps it's the case that parties who are more internationally focused, who are used to FIDIC and used to dispute boards, will be more comfortable with that in the UK, even with statutory adjudication. So just before this, actually, I looked up to see whether there had been any disputes arising out of this project in the UK, and I could only find one. And it was in fact an adjudication between the joint venture and a subcontractor, but there were no hint of any adjudication proceedings or enforcement proceedings arising from the joint venture who had a dispute board mechanism. And so that suggests that it was successful, that the parties found which is standing dispute board, which is one of the reasons I didn't accept it, was actually successful in the UK, and they didn't resort to adjudication, possibly out of familiarity. But addressing the informality or formality question, is statutory adjudication of dispute boards more or less informal? I think with dispute boards, there's a lot more flexibility for the parties to decide what sort of dispute board they're going to have. Is it going to be ad hoc? Is it going to be standing? To look at the nature of the project and decide, do we want quantity surveyors here? Do we really need a dispute board here to determine payment issues? Or do we really want an engineer because this is a state-of-the-art project, and therefore the type of disputes that are likely to come about are engineering disputes. But I think with adjudication, necessarily it's formal, but then also it's informal, because you've only got 28 days, only so much manning up you can do with experts in 28 days. And that really is the joy of adjudication, but potentially a downside on some of these big projects.
I think, Adrian, my experience is very, obviously I only get to see a certain type of event, which is a dispute requiring a QC, rather than the sort of more benign parts of the construction project. But my working assumption is that parties love the idea of a very informal process, and having, for example, a standing committee of professionals who can help to resolve problems until they're on the wrong end of some claim, and at that point, you know, they or their lawyers are suddenly reaching for, you know, the sort of procedure book and wanting everything either as part of their sort of defense armory to make difficulties with the other side, and or because when someone's making a claim against you, inevitably you want to find reasons to attack it, and you want to have a relatively just process, whereas the tendency of the claimant bringing a claim that may not be 100% sound in every detail, they maybe more typically want a relatively sort of informal process. Never mind the detail. Can we just have some money, or can we just resolve that? But that must be everybody's experience to some extent, isn't there? A sort of change in attitude between what you want before the dispute's arisen compared to how people behave when they've actually got a claim, very substantial claim being made against them.
I think so, and that's where one of the issues that has always occurred to me arises, because I think, you know, if we're talking about situations that are governed by the Construction Act, and therefore you have to have statutory adjudication in the contract, but challenging ourselves about whether there's a role for a dispute board to sit alongside the adjudication provision, because we have to have the adjudication provision, but it doesn't stop us writing in a dispute board. Obviously, you know, the parties then have a right to adjudicate, but they could also instead choose to go to the dispute board. And I think the dispute board could operate in one of two ways. It could operate before an adjudication in terms of a escalating dispute resolution procedure, more along the lines of FIDIC 2017, where you go to the dispute board along the lines, Justin, you mentioned, for early intervention, or to give a bit of guidance when the parties are probably have reached the impasse but haven't necessarily got a dispute. Or you could have an adjudication, a dispute board sitting alongside, almost parallel to an adjudication. But I think, you know, the issue with that would be one of, presumably, if you have a standing board where the board members are familiar with the contract, that may not necessarily appeal to everyone, depending on the nature of your dispute. You may have somebody that prefers to go to the dispute board because they think the determiner, who is more familiar with their project is more likely to find in their favour, or equally they may decide just to depart from the dispute board and go off to adjudication because they fancy their chances better with someone without that familiarity. And I think so there's quite a lot of scope, I think, if you have the two coexisting in that way to kind of game the system, and potentially quite a lot of wasted money as well if you were to have a standing board but then go off to adjudication and not use the standing board to resolve the disputes.
Yes, I mean,
I think though in practice that dichotomy between whether you go to adjudication and dispute boards, if the parties have decided to adopt a dispute board and it's set up, especially if it's a standing committee, then there would be quite a degree of sort of ill will or malafide to go off to adjudication. And I think on the sort of projects the bigger projects that would justify a dispute board, that's not a working model really, to rush off to adjudication to short circuit a dispute board. And I think as well, the sort of projects, 28 days is often not enough. And then if you extend those time limits, you're getting more towards a dispute board procedure anyway, but without the people who the parties have selected to be on the dispute board.
The thing about the 28 days is obviously it's 28 days for the adjudication and the responding party. It's not necessarily 28 days for the claiming party who spent 2 years putting their material together. My experience of dispute boards and like processes is that they often end up being very drawn out because you've got a tribunal of 3, because it's international, so people have got more reasons to take longer to do things, and you do end up typically with a much longer process than would be tolerated in a domestic adjudication, irrespective of the size of the dispute, and that does tend to lend itself towards, if anything, greater formality. I don't know, what's your experience, Adrian? I mean, in terms of the longer a dispute goes on for, the more likely it is to be something more like an arbitration and less like a sort of quick and dirty informal resolution process.
Yeah, I think that's right. And I know there are adjudications that are resolved within 28 days and without the help of external lawyers. But obviously the ones that we get involved in do have external lawyers, do often have QCs, are therefore nearly always extended, double, treble, quadruple the 28 days with a lot of cost attached to it. I think the related point to that is, can we therefore see dispute boards as fulfilling or filling the role as being something that's more informal, something that's a bit cheaper if we're assuming that adjudications themselves are more complex, longer and more expensive?
Well, that last point's really interesting, because I suspect that when adjudication was put into the legislation, there's a reference in the Act and the scheme about the adjudicator being able to take the initiative to ascertain the facts in the law. It may well be that the draftsman had in mind an adjudicator acting extremely informally, getting the bare bones of what the argument was about. There seems to be an underlying assumption that the argument would be incredibly simple and sort of a very short point about how deep a par needed to be or something. And the adjudicator just proceeding like as a technical person and forming a decision. And what has in fact happened is obviously nothing like that at all. So the comparison we're making is between what actually happens in adjudication versus what you could have in or what one hopes to have in a sort of standing dispute panel, where you have a representative of different 3 people coming from different disciplines to provide guidance and so on. So I suppose a question that arises is, has statutory adjudication failed to achieve that original objective, if that is correctly described? And if so, is a sort of standing DAB more likely to do that and have an agreed group of 3 professionals who you draw on as required to provide informal guidance or resolution of issues, but not in a sort of formal quasi-arbitrator role? That's the...
I think my experience is that dispute boards tend to be more uh, formal sometimes because they go on for long. But I've just seen that Matt Malloy's put a possible third way where we somehow try to join together arbitration and adjudication. But I wonder whether actually, so the idea of dispute boards, sometimes you have this standing panel of varying experts, a lawyer, QS engineer, whatever, and it could be that we try to join these together by saying, well, if you have an adjudication, the nominated adjudicator is going to be one of these individuals on the dispute board. So I guess you could try to work it that way, that you give the parties the option of having adjudication with very clear time limits, very clear enforcement, but you try and bring in the best, I suppose, of dispute boards, which is this ability to select from a panel of experts who are familiar with the project.
But Krista, what about Adrian's point, which is that in the context where you have statutory adjudication, in other words, a mandatory right to refer your dispute to adjudication, that's probably always going to favour one of the, in principle, there's always going to be one party who's going to like that, and one party who likes it a bit less. And you're never going to be able to stop the party who wants to from just saying, well, let's just adjudicate this.
But
well, I can see that happening more often.
Sorry, Chris, I was just going to say, my understanding of what you were just saying and what Matt was getting to in his question is, yeah, if for instance, you have an Act compliant adjudication provision in your contract because you have to, but you're actually making or selecting the adjudicators from what would be a standing dispute board running parallel on the contract, then I think that reduces the scope to all the risks to kind of game the system, because you know you've got dispute board members who are standing members sitting alongside, and if they're then being if they're putting on their taking off their dispute board hat and putting on their adjudicator hat, I think that probably eliminates or at least reduces the problem. It's just kind of quite how quickly and in what form they're making their decision instead.
But Adrian, there's a I mean the sort of the holy grail that I think we're kind of aiming at is a dispute resolution process that is genuinely informal and is not hung up on process and doesn't have all the baggage that arbitration, litigation, and since it really started, statutory adjudication seems to have. And I suspect that, well, I'm guessing, but when the adjudication was introduced, it probably was anticipated, for example, that an adjudicator could go to each party and get their side of the story. And the idea that, no, you can't have any communication beyond what time are we starting, can't have any communication without the other side being there taking a note. I don't know, I can't remember where that's come from. We will take that as a given now. Any adjudicator is idiot enough to speak to one of the parties without the other side. You know, it definitely wasn't like that when adjudication started. But I suspect that a dispute board, an individual who's trying to resolve an impasse rather than decide a dispute in a temporarily binding way, probably would want to go to the parties and get their take on it and act a little bit more like a mediator, which would obviously wholly disqualify them as an adjudicator.
Yeah, I suppose that we've all sort of worked on the assumption that adjudication dispute boards are similar in that the aim is to get an enforceable outcome. But I see David Glenning has put a question in that suggests that maybe we ought to be considering dispute boards as more of dispute avoidance boards. Yeah. And so that's a different creature, I think, from what we have been assuming is that something we're looking for an enforceable decision like adjudication. And in that case, he's saying, well, like, as you say, like a mediator.
The tiered approach I was talking about that FIDIC 2017 had, at least with the DAAB under FIDIC, it performs that dual function of being able to avoid and adjudicate disputes. So rather than duplicating the role of the DAAB in contracts that are governed by the Construction Act, where we have to have adjudication, it may be that we only have the first of the A's under the DAAB, and it's more of an avoidance role rather than an adjudication role. And we can, we know the fallback if that doesn't satisfy the parties is that they can go off to adjudicate instead. But the two different animals aren't performing the same function or overlapping. There's one before the other in that escalating tier.
I recall an initiative that was kind of sponsored, I can't remember which chambers was involved in it, but there was a kind of contractual mediation initiative a few years ago, which I haven't heard of late, but it was where you would have, I think the idea was that you would have a mediator, someone with mediation experience or accepted by both parties as being good as a mediator, who would be briefed into the project and would perform that kind of dispute resolution role as a mediator. And the theory would be that in this context of a really big project, their cost would be relatively low. They would have a bit of knowledge about the project, and they would act as a mediator to resolve disputes, so that nothing ever turned into a massive fist fight with a load of lawyers. But do you remember what I'm talking about, Adrian? As I say, it was literally about 15 years ago. I seem to remember it being canvassed, and you haven't come across a contractual mediation provision of that kind since it was being floated. So I'm assuming it didn't really take off as an idea.
Yeah, I haven't seen it referenced anywhere subsequently, although again I'm sort of familiar with it conceptually at least.
But I mean, do you think it's inevitable that all of these processes, whatever you call them, they will end up being more and more formal, whatever good intentions you have when you start out? If the project's big enough and the sums in dispute are big enough, which they will be in a big case, in a big project, you're bound to end up involving lawyers. Secondly, the lawyers are duty bound to do what they can to protect their clients' interests in the way that lawyers understand that, which isn't necessarily how other professions would see it, but a lawyer has a fairly sort of clear understanding of what their duty is in terms of protecting their client's interest, which may include taking unhelpful procedural points and all the rest of it. And then thirdly, there's the fact that all of these informal processes are intended to avoid some more formal process, which means that sort of counterintuitively, as we all know, they take on a much greater importance than you might have thought. So that what's meant to be a very informal, low-cost process, because it's going to basically be the only sort of fist fight that you have on that dispute, it ends up being extremely important, because whilst theoretically you have the right to have another go in arbitration, in practice that's the last thing anybody wants to do or probably will do. And that then means you end up in your ridiculously short period or whatever it is, going all out. And that's why we see these adjudications with everybody turning up and experts and all the rest of it. And so if I can just continue on a related point, I mean, I think when FIDIC introduced increasing sort of conditions precedent and requirements for notices and all the rest of it, in theory, that has the effect of sort of removing disputes, or removes late disputes at least. But obviously the effect of that is to put enormous pressure on every single notice, so that everything you do suddenly involves lawyers and has massive significance, even though the intention was to try and remove the extent to which lawyers are involved, or to reduce the amount of kind of formal dispute resolution.
I mean, I think it goes to whether you have confidence in whatever dispute resolution process there is. So the increased formality goes towards both parties perhaps wanting to invest more, so they get what they can consider to be the right decision, or a decision that they are happy to, that they're comfortable with. And so, and that applies to, for some cases, adjudication, but for other cases, the parties need. So for instance, in my example about Mersey Bridge, perhaps it was the case there that the parties needed a dispute board rather than adjudication, though adjudication would have been statutorily required, in order to have confidence in the process, so that we wouldn't get onto further arbitration or court proceedings.
Yeah, and I think you could avoid the formality and the involvement of lawyers if you did confine the role of the dispute board to the avoidance function, and said, okay, well, if you go to the dispute board there, what you're trying to do is avoid a dispute, so you don't really need lawyers to present your case or to articulate it in that manner, provided that there then is a mechanism, whether it's adjudication, if it's under the Construction Act or some other forum, to actually resolve disputes if the early use of the DAB isn't successful, and you end up having that dispute in the first place. Just one other question that's come in, I think, from Ben Hill, which is quite an interesting one. What are the panel thoughts on having a financial threshold established at the outset of the project whereby disputes falling under that level must be resolved by the DAB? I assume that means as opposed to kind of adjudication or some other form. As I see it, the difficulty with that is if the project is caught by the Construction Act, then that could fall foul of giving the parties the right to adjudicate at any time, which we need to be conscious of. But I don't think there's anything to stop the parties having a financial or other threshold if the project isn't caught by the Construction Act, which, you know, many of the long-term projects we're talking about in the UK, the PFI and the other projects, aren't actually caught by the Construction Act. So whilst they have these adjudication provisions, often they're contractual adjudication provisions, and therefore we're free to tinker with them a bit more than we can do contracts that are caught by the Construction Act and therefore have to be Act compliant.
I think that I think Ben raises a very good question. I mean, I suspect that when one has adjudications or disputes of any kind, you've got your sort of claim type final account or quasi final account type dispute, or some massive loss and expense type dispute. But then you have other arguments about who's responsible for something, whether something's a variation, and so on, which don't necessarily have an immediate financial value. I suspect that the DAB concept of trusted professionals that both parties are happy to have expressing an opinion on matters in issue lends itself rather better to the sort of non-financial type of claim where what's wanted is a resolution of what's in the contract, or what's extra, or what's an appropriate resolution to a problem. The sort of dispute that one anticipates Parliament had in mind when drafting Section 108, as opposed to the sort of the kind of kitchen sink, as it were, final account or penultimate interim payment type dispute that we all know and love from practice. The other point I wanted to make, Adrian, is, I mean, I started practicing in 1994 as a pupil, and started construction quite soon after that. And looking back to all those years ago, I think with my pupil masters, or the people that were silks in my old chambers in Otis, if they knew how much of my time as a QC was spent drafting or revising letters from contractors to the other side, all pretending to be issued by some junior project QS or whatever, but obviously written by some massive sort of legal team, I think people would have been, as barristers and solicitors would have been astonished at how much of that work goes on. And I think that, again, it's the way in which disputes have gone from relatively formal processes, primarily in the High Court, to various types of ADR, but which now means that relatively senior lawyers are involved in these, not just at the dispute resolution process, but the setting up of it and the putting in, the correspondence, arguing about the final account and so on. And I do enjoy all of that, and one much prefers having that involvement, so that when you then come to the actual arbitration or whatever, you know what's there and what you've done. But I do think that level of involvement of, for example, a QC or a senior solicitor writing or helping to write a letter, not even in a formal dispute process, that is indicative of this tendency for everybody to bring it. The more you try and keep things informal, the more the lawyers end up sort of finding work for themselves in relatively sort of informal processes.
Good point. Krista, Andrew Agliombi's raised another issue, which I think is interesting, and it picks up some of the other things we've been talking about. I think we focused so far on the sort of practical and strategic issues and advantages of having dispute boards sitting alongside before in parallel with adjudication. But he says, at a more formal level, is it possible to agree that the DAB would provide adjudication which complied with the Construction Act?
I mean, I think practically, I think all that's saying really is that the adjudicator will be the DAB. And so that you just have to make sure that procedurally it complies with the Act. But you wouldn't obviously have a problem with nomination, because you'd just be having a standing DAB and they must come to their decision in 28 days. So that's how it could work, it seems to me, in practice. But I do think you would lose some of the benefits that DAB has over adjudication.
Because you'd
But it
still
does
have to
depend on,
effectively have an adjudication timeframe that's Act compliant with
yeah.
the referral, the response and such like, and the time for the decision. But you're just substituting in the dispute board member to going off to a adjudicator nominating body, or however else you would get an adjudicator appointed.
Yeah, I mean, the beauty of that potential solution is that you've got a decision from a DAB which is enforceable. Like an adjudicator, you just go off to court and get it enforced. Whereas there's a lot less authority on enforcement of DAB decisions in the High Court. Maybe that's just a question of time, as perhaps we see more dispute boards in the UK. But at the moment, we all know if you've got an adjudicator's decision, you know, it's going to be enforced 98% of the time. But we don't have that strength, certainly, in respect of a DAB decision. So this gives DAB the added clout of that enforcement mechanism.
What about if you had kind of 3, 4, 5 person DAB? Do you think you would need to pick one of them to be the adjudicator, or would you treat the board itself as the adjudicator?
That's an interesting question. I think when I was thinking about this, I was thinking that the combination would be quite useful in terms of perhaps guiding the parties as to, well, if it's a payment dispute, you go to quantity surveyor X, but if it's a dispute about whether something's a variation, then Y, or if it's a novel state-of-the-art design and the issue is which design ought to be approved, or whether a design should be approved for construction, and then you pick the engineer as the adjudicator. But I mean, that's getting rather complicated as to how you would draft that. And then what happens if that person's not available to act within 28 days? Then you'd be probably stuck with going to a nominated body. So we'd be back with old style adjudication.
I mean, I remember that I used to do quite a lot of work on the underground when the PPP was first in place, and we had a dispute board in the same kind of way as that, which was effectively just a long list of adjudicators. Said if you have a legal dispute, go off to these adjudicators. If you have a quantum dispute, go off to these. And I remember by the time the end of it, nearly all of the people on the legal list, at least, had either died or become kind of Supreme Court judges. So none of them were suitable to act as adjudicators. But I think, at least as a concept, it's recognised to have that list pre-agreed at contract stage about who should determine particular types of dispute. And as you say, if you set up your dispute board as a standing board for the outset of the contract in that way, with a mixture of disciplines, then that would be quite a good way of doing it, quite a neat way of ticking the adjudication box as well, I think.
Yeah. There's a practical problem, though. There was one practical problem which I faced on this, is that if you want to be on a dispute board, quite often the parties will say you can't conflict yourself, which means you can't act for or against what might be fairly significant construction players. And so you might lose the best candidates because they don't want to conflict themselves for a potentially long-term contract.
I think, Adrian, a more recent example is Crossrail. I believe I've had a number of adjudications in relation to Crossrail. There's a panel of about 9 adjudicators. About 3 of them are construction silks, and then there are others from other disciplines. And obviously, as Krista points out, they then can't do any work for quite a large number of parties. But my experience of those adjudicators has been extremely positive. I think in terms of, I think we're talking about 2 slightly different things. Is the DAB and the sort of differences in how DAB works compared to statutory adjudication is sort of one topic, and then a different but related topic is the whole concept of having a standing panel of people, which obviously you can have for your adjudication process. You can have a list of people that have previously agreed to act as adjudicators, and you could, although I've never seen it, you presumably could have some further person who chose which of those adjudicators was going to do any particular case, so that if the parties couldn't agree or it wasn't obvious, there was some further party who would choose from that list, subject to availability.
Presumably you could have the chair of the dispute board selecting which of the dispute board members became the adjudicator.
Yeah, although that you have to sort of work to fit that into what section 108 actually says, but presumably the parties could agree a mechanism for choosing an adjudicator rather than having either a nominating body or a named adjudicator.
And Gordon James has said, well, this is all very interesting talking about it theoretically, but do any of us have any experience of how the mix of dispute boards and adjudication have been tried in any other country that has statutory adjudication procedures in their law, looking at how the two different concepts could coexist? I personally haven't, so that's a short answer for me. I don't know, Krista, whether you or Justin have.
It's only the Mersey project where I know both existed and have seen no evidence that there were disputes come to court suggesting the DABs were successful, but I don't have any experience really of how they've worked actually together.
But Adrian, I think the sort of premise of our debate potentially is that when you look at the standard forms, if you're covered by the Act, the assumption is that you're under section 108 and nothing else is permitted. I mean, isn't that the gist of what the printed form?
That's what the NEC guidance note says expressly.
So it's not. It would take a bit of a cultural change, or I mean, I think that was one of the, why we're having the discussions. Is it right not? Is it right to just assume that you're never going to have a case where actually it would be beneficial to have both? And so the answer to Gordon's question is no. We have no experience whatsoever of it, because it doesn't seem to be a solution that the standard forms propose. And the purpose of our debate is to discuss whether that's necessarily the right answer.
Exactly. One of the newer questions that's come in is talking about how you would involve subcontractors in this type of process. I think it's assuming that the dispute board would be in place between a kind of owner and main contractor at that level. How would you kind of bind subcontractors into this process? It's probably not an issue that looks specifically at adjudication, but it's quite an interesting concept nonetheless.
I mean, this goes to how you consolidate parties into essentially what is a contractually binding dispute resolution process. So probably the same issues arise as in trying to get multi-party arbitrations. And lots of the rules now seem to encourage that, so it would be the dispute boards to have the power to decide whether it was appropriate to pull in this case, a subcontractor into the dispute resolution process. Because often, one of the problems is that often is the main contractor and the employer don't actually want the subcontractors involved, because the main contractor wants to be able to play one game with the employer of saying we want an extension of time, and a different game with the contractor, the subcontractor, where they say, well, no, there hasn't even been any delay. So that's the sort of practical difficulty. But I think the same issues arise in arbitration in terms of consolidation as would apply to dispute boards. It is possible to draft it that way, but query whether the middleman actually wants it.
Well, Krista, you're absolutely right. But in my experience, there's also the situation where the middle party is neutral. They don't care whether the upstream people or the downstream people are right, so long as they sort it out. I mean, I've definitely done this kind of in a PFI project situation where I'm acting for project code with independent legal advice, and those behind the contractors behind the JV. But behind project code, have in effect got a dispute with the employer, and that ought to be resolved by sensible drafting and so on. Well, obviously there are quite a lot of types of disputes where it is in reality an argument about what the subcontractor's done, where they've got cascaded obligations, and where it ought to save everybody a headache to have that one single issue resolved as between the two parties that really care, namely the employer and the subcontractor actually doing that bit of work. I couldn't quite. What was the other part of the question? How to affront DAB's costs from subcontractors' claims?
Is it talking about how you deal with the costs of the DAB, how the cost of the DAB itself, assuming it's a standing board, are apportioned amongst the parties, I think.
Yeah, that's what I've seen. The cost of the DAB is shared. Otherwise, it doesn't. And so, if the subcontractor was to be involved, then there'd have to be some contractual mechanism for how the subcontractor was to share in those costs. But there's another interesting question that's come up from Svetlana Borisova, where she's asked, can a DAAB process be introduced as a risk management tool? And the reason that sort of drew my attention is because this debate really came out of NEC4, which now introduces dispute boards. And the interesting thing there is that in NEC3, there was quite a structure for risk management with early warning notices and risk registers, that sort of thing. And the NEC4 has pulled away from that formalization of risk and instead added in dispute boards. So it may be that Svetlana's right, that there is a movement towards using dispute boards in that way as a dispute avoidance or a sort of risk management, project management tool. That might be the way of filling the gap that now exists in NEC4 of a formal risk management structure.
But what do you think of that? I mean, if you've got an argument about, so a hazard arises on a project, and there's a question about how to deal with it, or something of that kind, well, you can see a case for some sort of management or risk management initiative or independent board or whatever. But if you're talking about to resolve that, and if the parties are unhappy, then to go take it further. But if what you're talking about is some massive claim for additional work, or a claim for extension of time or something, I mean, doesn't it inevitably mean that, well, sooner or later you're going to need somebody in whom the parties have reasonable confidence, and a process in which the parties have reasonable confidence in, to decide that dispute, and adding an extra layer that's yet more informal? I mean, it either doesn't really sort of count for anything, like when you have senior members of management having informal discussions, or it ends up just being the sort of something like a sort of relatively full-on adjudication.
Is the answer to that you wouldn't make that step mandatory? You could go straight to adjudication if you wanted to, and it's only if the parties, or at least one of the parties, felt that the more informal use of the DAAB could pay dividends, that you actually go to use them. I think the problem with that, obviously, is if you've got a standing DAAB that people aren't really using, you're not going to get your value for money. So you want to at least encourage a culture where people go there first to try and avoid getting into a dispute context, and the kind of adjudication or the escalating mechanism is really only used where the parties can't resolve their disputes at an early stage on a more informal basis.
I suppose what we see typically is that actually the project manager or the engineer on the project actually has that role and that status to resolve disputes as to risks that arise. And it's only when the parties don't agree with the project manager or the engineer's determination that you then have an issue that goes to, or a dispute then arises that you can take to adjudication. I suppose the idea is that rather than a project manager or engineer, that single person, you go to a more trusted dispute board who's truly independent, because the project manager and the engineer are generally engaged by the employer.
But Chris, did you accept my point that there's quite a big difference between risk management, as in a problem has arisen and how do you resolve it, and there's a dispute between the parties as to what the right solution is, versus the contractor is angry because what they consider to be additional work or delay isn't being properly compensated for. And the latter does require, if it can't be dealt with by negotiation, some sort of determination of whether that claim is valid. I mean, the risk in the context of risk management, the risk that's arising is the parties spending a lot of money arguing about a claim, but that's rather different from dealing with some problem that, for example, that when the contractor starts work, they find the ground is very different from what they anticipated, and how one that's risk management of trying to prevent the costs arising or mitigate the problem that may well give rise to differences of opinion that require to be managed and resolved. But all of that's a different sort of concept and requires perhaps different treatment to the project's now a year and a half late, and there's a massive barney as to whose fault that is.
I think one of the things I see a lot these days in particular is, when we're being asked to advise on adjudication, you kind of think, well, how the hell did the parties ever get to this point? Because this issue's been around a long time.
Yeah.
A year and a half, say something on ground conditions, point of principle, you think, well, it could easily have been resolved much earlier. And instead it's just being left to fester effectively, which is causing the parties to become further and further apart. And I think that's a definite area where sort of getting a dispute board involved at an early stage in an informal capacity should, in theory, be very helpful. I just think, I'm a massive fan of trying to nip things in the bud, and often the parties become entrenched in their positions, which is why you end up in these sort of long, formal and very costly adjudications. I'm not saying that all of the adjudications would be avoided on that basis, but does that accord with your experience as well? You kind of often see things thinking, well, how did we ever get to this point, and why wasn't this resolved much earlier?
I think so. I think that's right. And I think that actually there is a reluctance sometimes of parties who are involved in a big project to actually have a properly legal court or arbitration fight with the other, or even adjudication, because that's seen as somehow breaking the goodwill. So in that context, it might be that dispute boards could help to agree things in a formal way that isn't considered to be confrontational and therefore disrupts that goodwill.
I think Krista makes a great point, Adrian. I mean, the problem with you come to a case and you're wondering why on earth they haven't resolved it 3 years ago, and the difficulty for the parties is if every time there is a dispute they take it to adjudication.
Yeah,
They
sure.
spend a lot of time drafting referral notices, and that, as Krista says, that's also. I mean, that's presumably why you come to a project and there's all these sort of 1,000,001 things, some of which relate to variation order number 1 that is sat there, as you say, festering.
It's also, I think, why we commonly come across the issue where parties haven't issued claim notices on time, because claim notices and to a greater extent adjudications are regarded as a hostile step. So no one wants to press the button on an adjudication at an early stage of a project. I think it sets the wrong tone. But I think there is clearly a role that someone could play, whether it's a dispute board or someone else at that early stage in a kind of mediation type capacity, or just banging the parties' heads together, particularly if they've got that familiarity of the project, because there will be, as is mostly the case, that some things will go in the contractor's favour and some things will go in the owner's favour over time, and often it will kind of even itself out.
Well, maybe we'll just have AI doing all this quite soon, and it will all become totally sort of neutral. Your contractor puts in their claim, the computer gives you an answer, and no one feels any the worse for it.
Yeah, one of the points that's come up has been, we focus really on the UK projects that are caught by the Construction Act. Have either of you got any experience of projects in the UK that aren't caught by the Construction Act, where dispute boards have been used? Maybe that's sort of the first part of the question. And the second part, I think, is to look at overseas project where no doubt you will have more familiarity with dispute boards, but looking at in those projects how successful that's been, and whether the parties have talked about sort of introducing adjudication into overseas projects, albeit obviously not statutory adjudication because they're not caught by the Act. But have you seen any international projects where the parties have attempted to overlay kind of contractual adjudication, or for that to coexist with the dispute boards on those projects?
I think possibly it's how the stage that Krista and I get involved in cases, which is when they're very much sort of now into the dispute process. So my experience of dispute boards is there's been a long protracted period of negotiation, of senior commercial representatives meeting. There's been all sorts of tiered phases to try and resolve the dispute. And where the parties are now with when they bring me into the case is we're now doing this formal dispute resolution board process that with 3 people appointed by the ICC or whoever it is, or by the parties, and by that stage the parties are well past thinking about some more informal and quicker way. I would say that I do find again and again that the parties don't set up a board as such, or the contract doesn't require them to do so until the dispute's actually arisen. So then there's the question of trying to get the board impaneled and the delay that gives rise to. But I think the answer to your question is no, and in terms of the international cases, and that the parties and their lawyers want to get as much out of the process as they can. And if one were to say, well, why don't we have a much more expedited process in circumstances where the parties are in different time zones in different countries, and you know, there may be issues of translation and a great deal of work. My feeling would be it would not be particularly popular to suggest, well, why don't we just have 7 to 10 days for the response and a decision within 28 days and so on.
I mean, my experience in reflecting on the international cases I've done that have been through dispute boards and been through, you know, attempts to enforce those decisions at court and then ended up in arbitration. So the question is, well, you reflect and say, well, would adjudication have assisted in the dispute resolution? And I mean, a massive difference internationally is the enforcement. That's what happens. That's what we see in international cases, that you just can't get dispute board decisions enforced. And so if you don't have adjudication with the backing of enforcement in a local court, it's not adjudication as we know it.
Yeah, exactly. Question from John Halcrow. Does FIDIC 2017 not deal with these issues? The avoidance function requires mutual consent to proceed, but one party can trigger the adjudication function. I think that's probably right conceptually. It's been, I must admit, a year or so since I read the FIDIC 2017 dispute resolution provisions. My suspicion is that they would still need to be tweaked somewhat to make them Construction Act specific for use in the UK for construction contracts that are caught by the Construction Act. I didn't know, Justin or Krista, whether you've got any further thoughts on that point.
We did discuss this form and the introduction of the DAB. I think what maybe what John is getting at with his question is, doesn't FIDIC 17 show you how you can have these two processes, one being a sort of a consensual one and one being the adjudication function? Unfortunately, and this may be my failing, but I don't have any practical experience yet of the FIDIC 17 dispute resolution. I've been to plenty of lectures about it, but for whatever reason, all my FIDIC cases are looking at earlier versions of the form. But I would be interested to know, how in practice that is going to work. But I mean, my suspicion is that the FIDIC, if dare I say it, that some of the changes in the new FIDIC form are going to be quite difficult, including, as I say, hugely increased requirements for condition precedents and prompt notification of claims and all the rest of it, putting massive pressure on the drafting of letters and so on.
And I suspect there would probably be a natural justice point buried in amongst there, if you had the same person switching hats regularly between informally resolving parties' disputes, or at least kind of giving them some guidance, and then putting their formal adjudicator under the Construction Act hat back on and then switching to and fro. I suspect, going back to your point, Justin, about the sort of points that have been made in the past about why we can't now contact adjudicators separately and such, like there will be at least some case law developing on that point as well. It's a bit like under the Prague rules, where in arbitration, where the arbitrator can switch between being a kind of mediator and an arbitrator. I think it would give rise to similar problems.
Yes, that's right. Prague rules seem to rather dropped out of there was a lot of discussion about them a couple of years ago. They seem to have yeah.
I think we're probably coming to the end. I'm just quickly scanning the questions to see if there's anything we haven't picked up.
Well, there's a number of questions which are slightly similar, which are asking to the effect that whether statutory, well, the first question raised by Andrew, can the statutory adjudication requirements be satisfied by DAB or DAAB rather than coexisting? Can they be combined? A point that we keep kind of getting close to, but not actually answering, is I think under the mandatory statutory adjudication provisions, you have to have a sole adjudicator, and so any kind of setup that involves a panel of people would not comply with the Act. I mean, that would be my assumption. I don't know if you have a different view, Adrian. But you couldn't have a panel of people being your one adjudicator.
No, I think that goes back to the point that Krista was raising earlier, that you'd have to select one person from that panel to be the adjudicator,
Right.
to bear the adjudicator name badge, and then it's a question of the mechanism that you use to select that person.
Yeah, but I think the answer to the question, well, could the statutory adjudication requirements be satisfied by DAB or DAB? Well, the answer would be yes, but it would just look like adjudication, and it wouldn't really be any. It would just be an adjudicator, basically.
Okay, I'm just conscious of time and probably the need to wrap up. Where we started was challenging, I think, effectively the proposition from the NEC guidance note that if you have a construction contract that's caught by the Construction Act and therefore statutory adjudication applies, you can't have dispute boards. I think we've probably challenged that, and at least put up a compelling case for involving a dispute board in those contracts in some capacity, whether it precedes adjudication or whether it sits alongside and somehow forms part of the adjudication. Maybe a minute from each of you, Justin and Krista, just to wrapping up with any sort of concluding remarks.
Well, one thing I will say is that the pandemic, although it's been an absolutely dreadful event, has really enhanced the dispute resolution process, particularly in the context of informal and international processes. My experience of statutory adjudication and dispute resolution boards during the grim last 11 months has been unbelievably positive, and I think that's been a lot of people's experiences. So the future is bright in that sense, I think, in terms of where we go from here in terms of informal methods of dispute resolution.
Yeah, I'm not sure I can share your optimism so much. I think I was saying to someone the other year, I think 2019 is the year of notices. Sorry, 2020 is the year of notice, 2021 is the year of claims, and 2022 and beyond is the year of disputes. But Krista, what about you?
I was going to say that I think that the proposition is obviously wrong, that you can have adjudication alongside dispute boards, and the parties should really be astute to drafting their contracts so that dispute boards work in a way that's more flexible, and then it's just a question of which the parties have more confidence in as producing the right decision so as to avoid further escalation of the claims.
That's great, thanks very much. So I think it just remains for me to thank Justin and Krista very much. I think we've just started scratching the surface of this topic, and no doubt it's ripe for future discussion, maybe even an article or two somewhere along the line. This session has been recorded by the DRBF, so if you want to re-watch any of it or share it with your colleagues, please feel free to do so. There's a full slate of free seminars that are hosted by the DRBF on the website, which is drb.org. Please feel free, if you're not regular users of the DRB website, to log on, see what seminars are offer and get involved. There's also a very active LinkedIn discussion group for the DRB as well. So please do get involved. Thank you again, Justin and Krista. And thank you everyone for joining us. So we'll leave it at that today. Cheers.
Thanks very much for having us.
Thank you.
Great pleasure.